Thank you. If members could turn to page 7 of the staff analysis, it may be helpful because most of my comments will be geared towards the committee's second amendment. But first off, Mr. Chair and members, I am agreeing to accept the First Amendment contained in the analysis. I'm unable to accept the second committee amendment, not only because I'm going to lose the support of the advocates that have been working in this area for years, but I don't know how much of the bill will be left over to continue to move. Now, a property manager is the right arm of the board, and I've heard too many stories from the advocates of instances which the property owner has colluded with a corrupt and dysfunctional board. And let's just throw it out there. There's 52,000 homeowners association. I'm not talking about thousands of these things, but enough. Our democratic principles are important enough that we're trying to improve this and get it right, because those people that are affected are residents. Requiring that the inspector of elections only be paid for election work is essential for maintaining the integrity of these elections. The HOAs now function as de facto city councils with affecting people's rights. It's not a matter of cost. Not only is the opposition stated before in another HOA legislation that the cost of an election is $1 to $2 per unit. Let's call it 3 units. The staff report clearly walks out that most of these are less than 50 units, so it's not a big chunk of money. But there are also low-cost alternative providers. You have the League of Women Voters and other civic-minded nonprofits. As pointed out in the actual text of Section 551, which calls for the independent third party, may be a member of the homeowners association. So you could have a member that wants to do the election, but not a director or a candidate for director, or be related to the director or a candidate director. And again, Section 5110 says the independent third party may not be a person, business entity, or subdivision of the business entity who is currently employed or under contract to the association for any compensable services. Then they have that magic unless the homeowners association agrees by vote to do it. So the basis of the law is that we want to have this independent. We put in different language, and that's what we're hoping to remove here. I should also note that this bill is narrower than last year's bill, which passed out of this committee, and I'll just go over them. I've removed the privacy concerns from last year's bill. I've deleted the requirement that the vote counting location be accessible and near the HOA property, and I've alleviated all concerns from the building industry who has removed their opposition. And with me is Judge Tom Sir with the Center of California HOA Law, and I urge and I vote.
Thank you, Senator, and Mr. Chairman and members of the committee. The Center for California Homeowner Association Law is the one statewide organization that advocates for the rights of individual homeowners in HOAs. The Center has participated in the person of Marjorie Murray, our founding president, in the writing of the legislation, much of the legislation that protects the rights of homeowners, including in the area of elections. I became a member of the legislative committee and got involved in this kind of work after I moved into, retired from the court, and moved into a large senior community governed by an HOA, and learned, to my surprise, that my assumption that I would have the right to participate in the self-governance of that organization, just like I had in city governments wherever I have lived. And I quickly learned that that was an unwarranted assumption. I'd note that the exercise of the right to elect a board and to run for that board is the single sovereign act that a member is available to an individual member. Every proposed change in the law in this bill is based upon a significant number of complaints that the Center receives from all around the state. We have members from all around, every county. And we take these complaints and analyze them and try to work on fixes for these complaints And so that is the origin of the legislation. It's complaints from people around the state who have problems with the abuse of power by their board of directors. That is the origin. And so the question before you is really, may we move forward to fix the flaws in the existing law and to protect the integrity of the election process? And so I ask for your aye vote.
Thank you. Let me ask if there are other supporters of the bill.
Pedro Galvan with the Nonprofit Housing Association of Northern California in support.
Let me ask if there's any opposition to the bill.
Mr. Chair and members of the committee, Louis Brown on behalf of the Community Associations Institute California Legislative Action Committee. Today, in opposition to the bill, we have worked on this issue now for 2 years with the Senator and do appreciate some of the changes that have been made to the bill since last year, but want to note that this bill is significantly similar to the bill that was vetoed by Governor Brown last year for being a one-size-fits-all approach. We heard the author state that we're not talking about thousands of associations that have trouble with their elections. There's over 55,000 associations in the state of California, and those elections happen on a regular basis. They're fair, they're transparent. We have one of the most comprehensive set of election laws for homeowners associations in the nation. It's in the Davis-Sterling Act as well as in the Corporations Code, because these public not-for-profit corporations are governed by both sections of the code. SB 1265 was vetoed as a one-size-fits-all. As it was stated, with 55,000 associations in the state, 70% of them are 50 units or less. And yet we're making not changes to deal with just voter rights, we're making significant changes to the entire process that in most cases, 70% of the time, are generally overseen by volunteers. Those volunteers, if they make a mistake, this bill has created the gotcha at the end of it by changing the burden of proof that a court would actually look at. In today's law, if there is a mistake in an election and it happens to go to court, it is up to the judge to balance the facts of the case to determine if a mistake was made, whether or not that mistake actually had a result on the outcome, and if the judge decides that after balancing the facts, they can overturn the election. SB 323 turns that on its head by now stating that the association has the burden to prove that a mistake that might have occurred did not have an outcome on the election. If they cannot prove that, then the judge shall void the election. So what we're going to see is, especially in some of these situations where a mistake has occurred, the association can't prove it didn't have a result on the outcome, yet another election. And SB 323 has extended the time for the election to now over 150 days. The other issue with the bill is that it covers the election process, which happens when a special assessment takes place, when a change in the bylaws take place, when a board of directors election takes place. But the main focus by the proponents of the bill are the board of directors elections. So we've now changed the process for all these other activities that take place. We've increased the cost of this election for all these other activities take place for what we're seeing or what we're hearing is anecdotal evidence and problems with board of directors elections. The one amendment that the proponents, the author, are not accepting is rather significant. Because, again, this goes to the issue of not only dealing with board of director elections, it's all elections. So right now, in some cases where there is a community manager, that community manager is part of their business relationship, their contractual relationship with the association may serve as that independent third party. The CPA of the association may serve that role. The attorney may serve that role. With this bill and the changes that are being proposed, none of those entities, even those who are state licensed, have code of ethics regarding certain issues like this, could not serve in that role. Therefore, the association has no other another role but actually going out and finding a professional. Now, there may be volunteers that could do this, but under the current situation, current election rules, it's extremely difficult. Let's double the amount of time that the election is going to take place. Let's add additional steps. Let's add additional requirements by this independent third-party investigator of elections, and now ask a volunteer to do it. We're only going to create opportunities for more mistakes. We're going to create opportunities where more elections are going to be avoided and increasing the costs. Finally, to the point of the budgets, again, 70% of the association in the state of California, 50 units or less. 53% of the associations in California have budgets of $100,000 or less. Those budgets are paid for by the homeowners. Those budgets are primarily focused on the operation of the association, the maintenance of the property, the maintenance of property values. So every additional dollar that goes to some other process that is not warranted, especially on a statewide basis impacting 55,000 associations, will ultimately cost homeowners additional money. And in a time and in a state where we keep talking about homeowners and homeowner affordability, we just think that SB 323 is the wrong solution for this perceived problem. Ask for a no vote.
Well, I'm sorry. Madam Clerk, do we have any time left for the oppositions?
I'll be quick.
Okay, please.
My opposition is pretty much what was previously stated. Jennifer Wada, on behalf of the California Association of Community Managers, also here opposed for the reasons already stated. We do feel with the amount of HOAs in California that the one-size-fits-all approach is problematic, especially in this instance where these are volunteer board members who are giving their time, and it is particularly important given the scope of and significance of the decisions that they make for the homeowners in that community, for each association to be able to customize whatever election procedures are necessary to suit the homeownership within that community. So for the reasons already stated, we oppose the bill.
Any witness in support of the bill? Sorry, here you go.
My name is Rochelle DeStefano. I am fully in support of the bill. Thank you.
Support bill.
Let's bring it back to the committee. Let me just start by first clarifying the amendments that the chair and I had agreed to. I know there were two amendments that were discussed in the committee report. My understanding is you will be taking the first amendment around special assessments, which I think is a significant amendment to, again, ensure both clarity, but making sure that candidates are appropriately following what we need to see done in this. With regard to the second committee amendment, the author and I have discussed this. I think this is an issue we will continue to work on. I'm not going to ask or insist on that being taken for this committee. We can obviously have more discussion about that if folks so choose, but that is the discussion that the author and I had over the last few days. With that, is there any discussion by the committee? Mr. Diep.
Thank you, Mr. Chair. My concern about the bill that's before us is that I also live in an HOA, and I've participated in the local elections, if you want to call it that, and
You don't have enough to do.
I'm going to get off that board soon. But my concern about this bill is that I'm okay with allowing individual HOA to set standards. For example, some HOA doesn't have any requirement at all. Meaning, if you're a homeowner, whether you live on site or off site, you can still participate. Some HOA that I know of would allow or would limit eligibility to homeowner that actually live in that neighborhood, to make sure that he or she is familiar with the community. And so I'm not sure if we want to prohibit HOA from setting certain standards or guidelines on how candidates from these homes should be allowed or not allowed to run, especially when you have such a diverse group of HOAs. And I don't know if you've seen any problems or wrongdoing, but at least from Orange County, I haven't seen HOA becoming a problem because they game or they rig the election in a way where only their friends are allowed to run or seated on these HOA boards.
Right. With regard to the eligibility, I've taken the amendment on the special assessments. I had argued before that, if any members on the dais don't pay their taxes, that's an issue of the candidacy. You're not disqualified from running for the assembly. You have to answer questions on why you didn't pay your taxes. But with that said, I think that, okay, if you don't pay your special assessment, or you're not in a payment plan, or you have a right to, object to it in those hearings, then you're still eligible. But if you pass those things, then I've agreed to step away from that eligibility requirement. And there are, you're correct in that some HOAs set different standards on how long you have to live into the HOA to be eligible to vote. We're looking here, focusing mostly on the process of that election. And the actual time that people can be a candidate, what would disqualify them, and who can get on the list. And I know that there were the opposition raised a lot of points that I would be happy to talk about when it comes before the Judiciary Committee on their purview. We're here in housing on I think the assessments is a big part of the concern, and I've taken the staff recommendation. I hope that clarifies.
Any further discussion? Let me thank the author for moving this forward. I know this is a pretty comprehensive bill, and we've had a number of discussions around safeguards to the CID election process. My hope is we might be at the end of that relatively soon. But again, appreciate you taking the amendment on special assessments. And unless there is any further discussion, any final comments you would like to make?
I would say at the end of the day, it's about democratic governance. And what this bill hopes to do is, make things more democratic in the governance that people have that live in HOAs. It's just many of the things that we're asking for would be second nature if somebody just lived in the city, and we're asking for their elections of the people that make their decisions. So these are for the actual people that live in there, and with that, I would urge an aye vote.